Court is now in session. CRA 378 of 2024.
Your Honor, I am Counsel Clive Fernandes.
And Your Honor, I am co-counsel Mervyn DeNazareth. We are here on behalf of the state.
Your Honor, we are here for matter 378 of 2024. And Your Honor, we have brought forth the accused today to further examine him and come to a proper conclusion.
You may kindly bring the accused inside.
Firstly, I would like the accused to state his name for the record.
I'm Ajinkya Raut.
Mr. Ajinkya Raut, now I would like you to clarify something for us as well as the court. You have been charged with involving a child to commit a crime. Can you further elaborate on this?
I plead not guilty to this and have not done anything.
Your Honor, I would like to state that Section 95 under the B.N.S. penalizes hiring or involving a child in the commission of a crime. Mr. Ajinkya, what would you like to say on this?
I have no comments on this.
Now, I would like to draw the attention of the court to Section 137, which defines kidnapping. Now, Mr. Raut, please pay close attention to this section. So now, Section 137 includes the taking or enticing of a child for unlawful purposes. Now, Mr. Ajinkya Raut, please listen to this, and I would like the court to take special attention to this particular provision. Now, the Supreme Court has laid down that the term taking away means that the person is moved from one place to another without their consent. Secondly, enticing away means that a person is induced to move from one place to another by deceitful means. Now, Mr. Ajinkya, is it not true that you have taken the child away from his parents?
No, I have not kidnapped anyone. I was just selling balloons there and the kid just followed me. I'm not guilty.
Your Honor, through these actions, we can see how that the accused used balloons to entice a child to make it follow him. Now, Your Honor, through these actions of the accused, we can establish that issue number 1 has been explained. Your Honor, now we would like to move on to issue number 2.
Your Honor, I would like to draw the attention of the court to Section 139. Now, Section 139 further criminalizes use of a child for begging. Now, this section brings with it a presumption of kidnapping if a child is found begging. Now, Mr. Ajinkya, would you like to clarify why was the child seen outside your premises?
I have no comments on this.
But Mr. Ajinkya, we had some witnesses who made some statements. And as per their statements, they say that they saw the child begging outside your house.
The kid was underage, maybe he was begging. I have no idea about why he was there.
Your Honor, I would like to state that this ignorance cannot be held to be beneficial to the accused statement.
Your Honor, furthermore, I would like to draw your attention to Section 96. Now, Section 96 includes inducing a child with the intent that such child will be seduced or forced to elicit intercourse with another person. Now, Mr. Ajinkya, based on the evidence that we found, could you please clarify whether you took the child to the house of accused number 2 for this purpose?
No, I haven't taken the child there and neither did I know anything about it.
Well, Your Honor, Section 95 of the B.N.S. states that if a person uses a child for the purpose of pornography or sexual exploitation, they shall be penalized. Now, Mr. Ajinkya, you were caught filming this. What do you say on that?
The child was 17 years old. He was a male.
I would like to draw the attention of the court to the new provisions under the B.N.S. The B.N.S., unlike the Indian Penal Code, now identifies all children as any individual under the age of 18.
Your Honor, the law also now makes most child offences gender neutral. So, for example, Your Honor, Section 96 of the B.N.S. now says any child instead of stating whether it's a girl or a boy. So, Your Honor, through this we can see that the claim made by the accused as to it being a male and secondly the child being of the age of 17 shall be held as irrelevant in this case, Your Honor.
Your Honor, I think that concludes our examination.
On hearing both the parties, Mr. Ajinkya is hereby convicted under the B.N.S. for a sentence of 25 years of rigorous imprisonment along with a fine of 2 lakhs.
We hope this session has clarified some of your doubts with regards to the B.N.S. and child rights.
stay informed, stay vigilant, and if you have any questions, please seek the advice of legal professionals.
Or you know what? You better call.
I'm sure some of y'all are wondering, well, what happened to accused number 2? Under these circumstances, accused number 2 will not be tried in a normal court. Accused number 2 will be charged under the POCSO Act of 2012. And similarly, the accused number 2 will also be tried in the POCSO court.
Now, the POCSO Act is a comprehensive law which has been designed to tackle issues of sexual offences. It has been made in such a manner to tackle all sorts of sexual offences, and offences under this Act have been classified into 3 major categories. Firstly, sexual assault, secondly, sexual harassment, and thirdly, use of a child for pornography.
Now, the POCSO Act being a special law also has its own special courts. And secondly, similarly to the B.N.S, the POCSO Act also defines a child. It defines a child as anyone below the age of 18, and it takes a gender neutral stance.
Therefore, accused number 2 would be tried in the POCSO court under the POCSO Act and would be convicted accordingly.